Thank you, counsel. Justice Thomas, anything further?
Justice Alito?
Mr. Stewart, do you think that the constitutionality of this provision could be sustained on a theory similar to the one in San Francisco Arts and Athletics versus U.S. Olympic Committee?
I don't really think so, because I think that was really not a provision of general applicability. That was intended to protect the trademark rights of a particular entity in a particular trademark, and there was a unique history and a unique motivation. Certainly some of the subsidiary things that the court said in that case would be relevant here. But the other difference is that in the San Francisco case, what you were dealing with was the actual imposition of a restriction on speech. That is, the consequence of giving the Olympic Committee exclusive rights in particular words was that other people who wanted to use the same words in their marketing activities couldn't use them. And what we have here is something different. We're not dealing with an infringement case. We're not dealing with the question, can Congress pass a law that makes it a source of liability for particular people to use particular words? Really, we have the flip side. The question is, can Congress refrain from giving people exclusive rights in particular marks?
I said what I think about the government benefits theory in Mattel versus Tam, so there's no secret about that. And if your argument if I could not vote to sustain this without saying this is the attachment of a condition to a government benefit, or that it's analogous to the attachment of a condition to a government benefit, I mean, you don't need my vote to win your case. I'm trying to see if you have any argument that maybe you've just decided, well, Alito's a lost cause here. But whether you have any other argument, that one that doesn't require me to accept either of those propositions.
I mean, I'm not sure if this is fully responsive, because I do think at some level our argument in this case depends on the proposition that there is a difference between telling Mr. Elster you can't register the mark Trump too small, and telling him you can't sell shirts with that slogan emblazoned across it. If you think those two hypothetical restrictions are one and the same, they are legal equivalents, then we don't think that we can persuade you, because we don't think any government could prevent him from selling the shirts.
Okay, let me just ask one final question. What should one do? What should a justice or a judge do in a case in which the issue is the constitutionality of the federal statute, and this jurist thinks that it might be constitutional under a theory other than the one that is advanced by the government in support of the theory? Should the statute be held unconstitutional under those circumstances, under the party presentation rule, or should it be held to be unconstitutional as applied in the case at hand? What should one do in that situation?
I mean, I guess it depends in part on whether your objection is really to the theory or to the label. That is, if you, in the following sense, if you agreed that there is a constitutional difference between refusing to register the mark Trump too small and prohibiting the use of the mark Trump too small on T-shirts, if you agree that there is a legal difference between the two, but you're hesitant to characterize federal trademark registration as a benefit, we may still be able to persuade you, because, as I said, the real question is whether this is an abridgment of speech. And for those purposes, at least part of the issue is there a difference between refusing registration and telling you can't market the shirts? The one other thing I'd say about Tam is Tam was a case, as you recall, in which members of a musical group of young Asian American musicians wanted to register the mark The Slants, and they wanted to use that mark because it had historically been used as a derogatory term for Asians. And they said, our goal is to reclaim and assert ownership of the mark. They wanted to show that they weren't cowed by derogatory treatment from others. I think in that case they had a real argument that to express themselves fully effectively, the slants had to be the official name of their band. It wouldn't be sufficient if they had adopted a more anodyne term as the official name and then had referred to themselves colloquially as slants. And so TAM was really the rare case in which there was real expressive value in choosing a term as a source identifier rather than simply using it.
Thank you.